Well, this topic will not be boring for you. This is a very exciting topic on same-sex marriage. It is similar to like the civil rights movement, where there were changes made state by state, and then at the federal level, and then at the Supreme Court level. Today, Omar and I chose this state serendipitously. We chose the state for same-sex marriage maybe 2 months ago, 6 weeks ago, but today is actually very appropriate. A, today is National AIDS Day. B, yesterday was the end of National Adoption Month, which pertains to same-sex couples significantly. And Monday may be the announcement for the first time of the Supreme Court of the United States, of which I'm a member of the bar, making decisions concerning same-sex marriage. So this is very apropos today. And it's also after the election where 3 more states adopted same-sex marriage. So let's start with some of the history and some of the detail so you can get the background of what's happening in today's world concerning same-sex relationships. In order for there to be freedom to marry, every state and the federal government must recognize same-sex marriage in order to achieve full equality for same-sex couples and co-parents. Currently, there exists the Defense of Marriage Act. The Defense of Marriage Act, also known as DOMA, is a federal law signed by Bill Clinton in 1996. He now is against DOMA and for same-sex marriage, but that was passed in 1996. Section 2 of DOMA allows states to refuse recognition of same-sex marriages. Section 3 of DOMA defines the words marriage and spouse in a way that removes all same-sex couples, married or unmarried, from all federal statutes, regulations, and rulings that are applicable to opposite-sex married couples. If we look at Section 2 of DOMA, it states, no state, territory, or possession of the United States or Indian tribe shall be required to give effect to any public act, record, or judicial proceeding of any other state, territory, possession, or tribe respecting a relationship between persons of the same sex that is treated as a marriage under the laws of such other state, territory, possession, or tribe, or a right or claim arising from such relationship. Section 3 of DOMA states, in determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the word marriage means only a legal union between one man and one woman as husband and wife. The word spouse refers only to a person of the opposite sex who is a husband or wife. Under DOMA, the federal government does not respect a same-sex marriage for federal purposes. DOMA creates an exception to the full faith and credit clause by permitting states to disregard the marital status of same-sex couples. Under DOMA, same-sex couples are denied over 1,000 federal benefits and protections. So in other words, if you are a heterosexual couple, there are things you don't think about. Social Security, survivorship rights. If you pass assets to each other, you do not have to pay a gift tax. Immigration is a huge one. You can sponsor your spouse. These are things that heterosexual couples take for granted. Even in states where there's same-sex marriage, same-sex couples do not get these protections, okay? So some of these benefits include retirement rights and health benefits as federal civilian employees, no tax-free transfer of assets, no maintenance deduction. So in a divorce, where there is no same-sex marriage, or even if there is same-sex marriage on a state level, it's not the same as doing a divorce with a heterosexual couple. So I've practiced matrimonial law. I've been doing divorces for over 26 years. I must have handled over 1,500 divorces in my career. Normally, you do a lot of strategic planning with the agreements using tax consequences. So the issue of maintenance or alimony, what we would do is we'd say, okay, we'll give more maintenance or alimony to one spouse because both spouses can benefit. It's a win-win because alimony or maintenance is a tax deduction, okay? It's a federal tax deduction. So if you're heterosexual, you can get a federal tax deduction for giving alimony or maintenance. However, if you're a same-sex couple, even where same-sex is married, because of DOMA that still exists, then basically you cannot get that deduction. That's significant. Retirement funds, this is a huge area, okay? In divorce, one of the major assets of the case is the pensions and retirement funds. It applies to ERISA, it applies to 401ks, it applies to IRAs, and it applies to many qualified pension plans. So even in a state that has same-sex marriage, maybe you'd be entitled to the state ERISA to transfer the asset if you're a same-sex couple that's married. But in a divorce of a same-sex couple, you couldn't get the federal retirement benefits automatically transferred without paying a tax. There's something in New York and in other states when you transfer retirement funds pursuant to a divorce called a qualified domestic relations order. And that means that the pension administrator has to recognize that you are getting divorced and that your spouse has a piece of the pension, okay? And that transfer is tax-free. That's a huge saving to be able to transfer assets and retirement funds tax-free. Can mean the difference between 1/3 to 50% of the asset or the retirement plan. And guess what? Same-sex couples cannot get the federal tax benefits in that situation unless DOMA is repealed, which is what the Supreme Court may be looking at. So you have to follow the news very carefully on Monday. If it's not Monday, it may be next Friday. What happens in repealing DOMA is that 9 justices of the Supreme Court get together, only the 9 justices, and they meet in the Chief Justice Roberts' chambers, and they decide what cases to take up. There are 8 petitions involving DOMA, the Defense of Marriage Act, that are before the U.S. Supreme Court as we speak. That doesn't mean it's 8 different cases, because it's 8 different petitions. Some of them involve the same case. So some of the petitions are brought by the Department of Justice, who want to strike down DOMA. President Obama historically came out for same-sex marriage back in May, and his administration refuses to support DOMA. However, the Republicans in the Congress are supporting DOMA, and we'll get more into that later. So there's 8 petitions, and there's some other cases involving same-sex marriage that are more narrow that we'll talk about later. But these federal benefits are absolutely at stake in these cases. Same thing with Social Security and survivor benefits. Normally, a spouse would be entitled to survivor benefits, but if the federal government doesn't recognize you as a spouse, then you cannot get those survivor benefits, okay? It also applies to things like Medicare. I was just reading an article about insurance planning. Same-sex couples, until DOMA is repealed, or if the same-sex marriage is not recognized in their state or at the federal level, have a lot more insurance planning to do. Because basically where there would be a transfer of assets permitted, like pursuant to Medicare, there are certain assets that permitted that you can still get Medicare even if you transfer to your spouse, or you can delay transferring the primary residence, the house, okay? However, if you're a same-sex couple, that doesn't apply to you. And therefore, you may need more insurance to cover the tax consequences when you transfer these assets, okay? The trickiest part is tax returns. I know all of you file a tax return. You can relate to this. Some of you may be too young to worry about retirement funds, but you can definitely relate to taxes. So, it's very tricky. With a same-sex couple, if they live in a state where there's same-sex marriage, and currently there are 9 states that recognize same-sex marriage, in the last election, 3 more states are part of that 9 that joined, and also Washington, D.C. So on the state level, you can file a joint tax return. But can you file a joint tax return on the federal level? According to DOMA, you cannot. So this makes tax planning and the accountant's job very tricky and expensive for the same-sex couple. What happens is they have to plan and prepare a state tax return as joint. Then, in order to figure out their federal taxes as single, not married, they have to prepare a state tax return as single. So they then file a joint tax return by the state and separate tax returns on the federal level. It's like bending themselves into pretzels. So this is what's at stake. Okay? In order for same-sex married spouses and their families to obtain the full benefits of marriage, they must reside in a state that has legalized same-sex marriage or honors an out-of-state same-sex marriage by comity. Comity is a principle where a foreign law or judgment of another state or country is granted full faith and credit and thus deserves recognition. So let me explain. Basically, there was a custody case, which I'll talk about later, called the Deborah H. case, okay? And what they found in that case is that although New York didn't recognize the second parent, it was a same-sex lesbian couple, and they were determining custody of their child. And one was the biological, and it was done by artificial insemination by an anonymous sperm donor. But the other parent had held herself out as a parent. They lived together. They were both known as mom. They both raised the child together. However, when they divorced, the one parent, who was the biological parent, didn't recognize the other woman as a parent. So it's interesting because people who were very involved with same-sex issues and same-sex rights and are lesbian or gay themselves, but when they get divorced and they don't want their other partner involved, they may deny it's a relationship. So it gets very tricky. What happened is that the only reason that the second parent, Deborah H., was recognized as a parent and had standing on the best interest of the child in custody was because of a principle called comity. Because the couple had participated in a domestic union by law in Vermont, New York had the right, pursuant to the principles of comity, which means you can recognize an out-of-state judgment, to accept the couple, okay? Similarly, in family law, for instance, if a couple gets divorced in another country or another state, as long as it's not against public policy, New York State or different states in this nation have to recognize those judgments pursuant to the principle of comity, okay? So let's look at same-sex marriage in the United States. Same-sex marriage has been legalized in the following states. Massachusetts was the first state in the country to legalize same-sex marriage, and that was May 17, 2004. Connecticut was in 2008, Iowa in 2009, Vermont in 2009, New Hampshire in 2010, New York was last year, June 24th, 2011, Maryland was November 6, 2012, Maine was also recently, in this last election in 2012, and the state of Washington was also recently in this election. So 3 states joined in this election: Maine, Maryland, and Washington State. And the District of Columbia, it was legalized on March 3rd, 2010. Now, in addition to some of the states having same-sex marriage, the 9 states we spoke about, plus Washington, D.C., there are other states that have domestic civil unions, which means they recognize the couple as a domestic partnership. It's not the same as marriage, but it grants some level of protection. And then there are states that recognize domestic partnership, but also with a certain level of protection as if they were married. They just don't want to call it a marriage. So you're dealing with a lot of history in America. You're dealing with competing interests of religion, economics, politics. So I think that's part of the reason you get all these varied definitions. As I said, similar in the past to the civil rights movement, not exactly the same. I mean, the civil rights movement came out of slavery. We don't have that with same sex, but certainly you've had discrimination. So I think, there are many similarities to the Brown versus Board of Education case and the end of segregation in this country and the changing of civil rights laws state by state and then bringing it to the federal level for some equal protection. So right now we are all a part of this history. So with civil unions, Hawaii was the first to pass a civil union in 1993, and then in 2004, 11 more states created domestic partnerships, but that doesn't mean they all exist now because the laws keep changing in various states, and we'll get to that. So a civil union or a civil/domestic registered partnership, and then there are unregistered cohabitation statutes. They offer varying legal benefits of marriage and are available to same-sex couples. Some of those states include California, Delaware, Hawaii, as I mentioned, Illinois, New Jersey, Nevada, Oregon, Rhode Island, and Wisconsin. Now, in response to states taking some positive action in same-sex marriage, there was a reaction. And many states passed what I call mini DOMAs. So they passed a Defense of Marriage Act in their own states, okay? They're called mini DOMAs. So it's Mini Defense of Marriage Act. And some states, they've done it in 2 ways. Some states have adopted, many states actually, have adopted what's called a constitutional amendment to their state constitution to say that marriage is only between one man, one woman, and banning same-sex marriage. Some of them have done it in response to referendums. Some of them have done it in response to the same-sex movement, also known as the lesbian, gay, bisexual, transgender movement, LGBT. And so there's this backlash. This is the history of our country, right? Even under Abraham Lincoln. So we go back and forth. Many states have the mini DOMAs, okay? In addition, 10 other states have adopted statutory mini DOMAs. So one is done at the state constitutional level, others is just done by the legislator in each state, all right? And in the last election, North Carolina became the latest state to adopt a mini DOMA. If you go to, there's a website called the Human Rights Campaign. They have many of the charts showing marriage, equality, and other relationship recognition laws. You can see them in chart form. They also have a chart called the Interstate Relationship Recognition, where you can see color-coded which state recognize out-of-jurisdiction marriage licenses issued to same-sex couples. So there are certain states that will recognize marriages from other states. New York was one of them till it passed its own same-sex marriage law, but it will still recognize a marriage, a same-sex marriage that was done in another state. In addition, Vermont has comity and Washington, D.C. has comity. Then there are states that recognize out-of-jurisdiction marriages and civil unions, not just marriage, as a valid civil union or domestic partnership. So they might not recognize it as a marriage, but they'll recognize it an out-of-state same-sex marriage as a civil union or domestic partnership. And as of May 27, 2011, there were 7 states that did that: California, Delaware, Hawaii, Illinois, New Jersey, Oregon, and Washington. Then there are some states that recognize out-of-jurisdiction marriage licenses issued to same-sex couples as valid marriages, but they will not recognize other forms of relationship recognition. So they will recognize the same-sex marriage, but they will not recognize the domestic partnership. And those 5 states are Connecticut, Iowa, Maryland, Massachusetts, and New Hampshire. Now, the states that prohibit marriage by the mini-domas with constitutional amendments, as of 2010, some of those states included Alabama, Alaska, Arizona, Arkansas, Colorado, Florida, Georgia, Kansas, Idaho. I mean, there's many states. It's 29 states. So 29 states, as of 2010, created constitutional mini-domas. And then, as I stated, there were 10 states, in addition to those, that created legislation prohibiting same-sex. But as of those 10 states, 2 of them now have same-sex marriage. They struck down their own legislation, and that was Maine and Washington State. Okay. There's also something called superdomas. Some state constitutions have been amended to deny all forms of relationship recognition to same-sex couples. So not just marriage, but any domestic partnership at all. These are called superdomas. And some have adopted statutory superdomas. Now let's look at the history of same-sex marriage. In 1993, marriage equality had its first temporary success in Hawaii, where the Supreme Court decided that restriction of marriage was unconstitutional. The state constitution was then amended to allow the legislature to preserve the restriction. Other states followed suit, amending their constitutions and statutes to prohibit same-sex marriage. Massachusetts became the first state to permit same-sex marriage. In 2003, the Massachusetts Supreme Judicial Court held that excluding same-sex couples from the benefits of civil marriage violated the state constitution, and that was in the decision of Goodridge versus Department of Public Health. In 2004, the court further held that a civil union law would not be sufficient, and later that year, Massachusetts became the first state to legalize same-sex marriage. California has a very interesting history, and it's one of the petitions that are before the Supreme Court currently. And that also affects many same-sex couples, obviously, because California is one of the largest states. So in May 2008, California became the second state to legalize same-sex marriage when the Supreme Court held that laws restricting marriage to opposite-sex couples were unconstitutional. And this was in re marriage cases. They did it broadly. But then Proposition 8 came. Proposition 8 was a referendum, and in November 2008, the voters of California approved Proposition 8, a constitutional amendment which eliminated the right eliminated the right of same-sex couples to marry. Okay. In May 2009, the court held that marriages of same-sex couples performed prior to the effective date of Proposition 8 remain valid and must be recognized in California. That was in Strauss versus Horton.